Good Saturday morning to everybody, and welcome to Legal Notes with Mary and Charron and Ned Barron. I am Gary Byron. They are from Charter Oak Law. Good morning, gang.
Good morning.
How are you?
Good morning.
Good to see you.
Good to see you, too.
We've been talking a lot over the last couple of weeks about Medicare, Medicaid. More on
I know.
Yeah, I know. It's probably been beyond a couple of weeks. Medicaid in particular, that it sparked an email from somebody. You want to go into that, Marian?
Yeah, sure. So Medicaid is pretty complicated, and it's something that people who call us tend to have a lot of questions about, and that's one of the reasons why we spend so much time addressing it on the radio. And we have been receiving questions and emails, but most recently we got a pretty detailed one that Ned and I both thought was worthy of trying to parse out and address some of the issues that were in this. It was actually a fax, but I'm calling it email that we received. And so, Ray, if you're out there listening, I promised you that we would address it. And he has an interesting circumstance. So his wife's parents, I think it's a father and stepmother. The father his father-in-law created a trust. So when he passed away, there was a trust for the benefit of his wife. And then at the wife's death, it goes to the children. All right?
Not to Ray.
Not to Ray.
Okay.
No, he's going to stay
because
married.
He's the in-law.
He's the in-law. He has to stay married
Right.
to his wife. No.
Well,
Or spouse. And so his question really had to do with, well, what if his mother-in-law needs Title 19? Like, what is the state going to take the money that's in trust? What's going to happen?
good question.
And I thought that was, how about the income? How is the income treated? And he really wants to know, how much, if any, or all, is the state going to take? And I thought that was, there's so many pieces of that Ned and I wanted to address today, this morning. And I think it affects a lot of people. So that's what his email was about. So thank you, Ray, for your detailed email. One of the things that I had told him in my email response to him was, we really need to see your father-in-law's trust document. So Ned and I are going to be addressing all of these pieces today on the radio show from a general perspective. You know, some basic information. Obviously, trusts are private documents. They're contracts, so to speak. And so you can put certain language in there, which could be different than what Ned and I are going to be talking about this morning.
It's curious, though. How are assets held in trust treated by the state?
You want to take that one?
Well, and this is a typical attorney answer.
Okay.
It depends.
Oh,
Right.
no.
And it really depends upon the terms of the trust. And when I say terms, as Marian was referring to, is the language.
So let's assume for this question, it's a lifetime trust for the benefit of the spouse. Let's just take that as a general. So he dies, husband dies in this case, and leaves whatever asset, the trust assets, real estate, investment accounts, in a lifetime trust for the benefit of the spouse. Okay.
Right. Well, so again, it still depends on the language because because in a world where, let's just say that we're not concerned about the need for qualifying for Medicaid down the road, that typically what the language would say about that is that the surviving spouse is the beneficiary. And what the terms say is that surviving spouse is entitled to the income of the trust automatically. And just to give you a little background, so trusts are comprised of two components. One is the principal of the trust. So that's the underlying investments. So if I create a trust and I put $1 million in that trust, that $1 million is the principal of the trust. Well, that $1 million is hopefully going to be invested in something that's going to be generating either interest or dividends. Some sort of income is being generated from that $1 million, and that's called the income of the trust. So in trusts, we have principal and we have income.
Right.
And so in most trust documents, that those are treated separately. And so the provisions that I was just speaking about was that in a typical trust that's left for a surviving spouse, that it says that surviving spouse would be entitled to the income, the net income of the trust.
Okay.
And when I say net
And
income,
that's pretty typical. We want the spouse to be able to have all of the income.
right.
All right. So that's a pretty typical thing, because usually the spouse who died wants to make sure that the surviving spouse has an income stream. Maybe that person got a pension.
Sure.
Maybe that person got Social Security. They're not going to have it anymore. So income is pretty typical. Now, principal.
Yeah, and there's also income tax reasons for that.
Yeah.
Trusts generally are taxed at a much higher rate than individuals are.
Yes.
And so you want to pass through that income to the beneficiary because the tax rates are going to be lower. So that's another reason why that's done.
Yeah.
So the income, and it's the net income, and that's an important concept to understand too, because trusts that are those types of trusts are going to have their separate tax ID number. That means that they're going to be required to file federal and state income tax returns
Just like
every
people,
year.
right? So the government's going to want its share.
Well,
and so
of course.
it taxes individuals, and we have to pay we have to fill out a 1040. Trusts fill out a document that's called a 1041, right? So if we give all the income away to the beneficiary, there's not going to be anything to pay the taxes. So that's why it has to be net income.
Right. But the IRS still wants to have documentation that income was passed through to the beneficiary.
Yeah.
So those trusts do have expenses. Let's say an accounting expense, right? So the net income would be net of any accounting expenses.
So then we know the surviving spouse is going to get the net income. So let's talk about principal.
So principal, oftentimes what the language says is that that the surviving spouse is allowed to receive distributions of principal. So this is the underlying assets, is allowed to receive distributions of that for that would typically have to fall under a category which the IRS calls an ascertainable standard, which in most cases it's health, maintenance, and support.
Right.
So any distribution of principal to that surviving or to the beneficiary from that trust would have to fall under one of those categories. And it's pretty easy to figure out, well, medical, right? So medical could be, paying for copays, paying for procedures that are not covered by insurance, paying for a home health aide to come in, so that's pretty easy to figure out.
And one of the reasons why that we're taking the time to talk about the difference between principal and income is because for Medicaid qualification purposes, if somebody has income, again, we talked about whether it's Social Security income, whether it's pension income, dividend income from the trust, you get to spend it just like it's your income, right? So if you spend it for your care and your expenses, that's what you're entitled to do. Title 19, the state is not going to try to take away your money unless you gift it to other people. We talked about that last time. If you start giving your money away to your family members, then that's an impermissible transfer. Now we talk about invasion of principal. So if the trust has language that allows the invasion of principal at complete discretion, then it's really important to know that trust asset the state would say that that's includable. Okay, so it's not going to be, it would be included in your assets that have to be spent down for purposes of Title 19. And I know, I can already feel you wanting to talk about the exceptions, but there certainly are reasons, like Ned was talking about. If the principal is invaded for the ascertainable standard, right? If you need it to pay for your care, if you need to invade principal because you need to make modifications to the home for handicap access bathroom and things like that, right? So there's all sorts of very good reasons that are not going to penalize you. But essentially, if the asset is accessible to you, if the principal is accessible to you, the state is going to say it's accessible to me.
Right. So the scenario for Medicaid purposes that you're in a nursing home, they're going to say it's accessible for you to be used to pay for your care.
Right.
So you have to use that money up first before Medicaid will kick in and start paying for your care. So as Marianne was saying, and that was the qualification that I was going to make to what she was saying, was that
I could feel it.
Right. If you can, if you as the beneficiary can basically force the trustee of the trust to give you money, then that means the state can force you to withdraw that money to pay for your care.
So then what happens when a beneficiary spends the money in the trust?
We talked about that a little bit.
Yeah, but will they be penalized?
Depends on what you spend it on, right?
So, but if they they won't be penalized as long as they make those accessories to the bathroom for handicapped accessible. Right, but if they blow it off on vacations,
that's fine too. Spend it on a vacation. Take mom on a vacation. Well, I shouldn't say let her go on a vacation, right? But if she goes on that Alaskan cruise and takes the whole family, then that's a gift, right?
Okay. See, I'm glad you said that then, because I did not know that. That's actually acceptable.
So,
but if she took one person, let's say she was frail, and she took one person with her, then that could be an exception because
otherwise she wouldn't be able to go on vacation.
Right. So she needed the assistance. Right. It was someone that was there to help her.
And I've certainly, when I've done conservatorships, and I'm sure you have too, is that I have allowed as part of the spend down for someone who I've been conservator for. So the individual said, I want to go. In this case, she wants to go to Italy. We didn't have the money for Italy. Instead, I sent her to Vegas, and she stayed.
At the Bellagio, right?
She did. And you know what? She didn't know any different. I'm sorry. and she went with a friend who was the caregiver, right? Who became the caregiver because she would never
be able to go without that person.
I had no problem qualifying the expense of that trip for Title 19 purposes, right? So go on vacation. You're entitled to entertainment, right? But let's say use that money to buy a car for you, Gary, right? Let's say she said, okay, I love my son-in-law, Ray, okay, and I want him to have a new car. That's a gift. That's a transfer. That is
not accepted.
Right.
All right.
So getting back to the language in the trust. So what we've been talking about is a type of a trust that would not protect, so far the language we've talked about, would not protect any of those assets from the long-term care needs. Would not help to qualify someone for Medicaid and protect and to shelter assets. So what we would need to do is include other language, additional language in the trust that would instruct a trustee that while so far we've said, well, the distributions of principal can be made to the beneficiary under these ascertainable standards. However, if that beneficiary is in a nursing home or receiving or looking to receive government aid, then those discretionary distributions are cut off.
Right. So you can have the language in the trust. So he's absolutely right. We will, in some instances, if that is what we want to do for our client, right, there would be additional paragraph that would say, all right, surviving spouse can invade principal. Surviving spouse gets income. However, if at any time surviving spouse needs nursing home care, we can cut that person off. The trustee has the discretion to not make any more distributions. And that is a huge difference. That is such a big point because the state looks to see if the trustee has discretion or not to make the distributions, right? So how much is the trustee's hands tied? Well, they're tied if we have language in there that ties their hands. But if the trustee has the ability, if the money's accessible, the money's accessible. I do want to make a point about trustee. I don't know. Ray certainly didn't mention in his question who the trustee was of this trust. But if the surviving spouse is the trustee for him or herself, then it is completely accessible.
Well, except one thing that I would argue is that if they're needing nursing home care, they're probably not the trustee any longer. Right. So there's going to be a successor trustee that's going to be named, someone who's going to step into their shoes.
All right.
And now we're talking about someone who is not the person who is seeking.
All right. So that's true.
Medicaid.
If they clearly don't have capacity and they need a nursing home, hopefully the trust does have a successor appointed and it would be someone else.
Folks, you are listening to Legal Notes with two people from Charter Oak Law. 2, not 3. I'm just a facilitator here. There's only 2 individuals who practice law of this trio here. Ned Barron and Mary Ann Charron. Was I incorrect?
No, thank you.
Oh,
honey.
okay.
So
2 individuals?
Just never heard you
I know.
describe us in that way.
Gary's going to be able to, assist people soon enough.
Well, I'll tell you something. Doing these shows, I do learn more and more about it,
So,
And the funny thing is that you are bringing up things that really that a lot of people don't know much about, but they heard of.
I know.
They heard of this, but they don't know much about it. It's really one of the benefits of this show is that you're really educating so many people at once on things that, oh yeah, I heard of that. Hey, family members will get in arguments over, no, I don't think you can do it. Yes, you can. No, you can't. And that's the beauty of this.
So, and it's such a tough topic, and I realize we can get kind of lost in the details of it, and there's so many exceptions, so when Ned and I talk in generalities, we both know that there's exceptions to every generality we've been talking about.
Oh, of course.
The only other thing I wanted to talk about in Ray's email was he doesn't say if the surviving spouse is the sole lifetime beneficiary. Oftentimes there is language that says that the spouse and children are beneficiaries, right? So sometimes they don't want to just limit it to the surviving spouse, is that there can be distributions or gifts or invasion of principal for the other beneficiaries, which can be the children, right? So,
Yeah. Just be careful about the language because you said gifts. So
That's
from a
true.
trust, it
Thank
would not be
you.
a gift.
Okay.
Yeah.
That's why it takes 2 of us. Okay. But you're right. I mean, language is important, and the written language in the document is important too.
Is there anything that pertains to spousal responsibility for bills?
Not in a trust, but certainly spouses have responsibility. You want to talk about that?
Sure. So when we talk about bills, obviously that could run the whole gamut, right? Electric bill,
Anything. Mortgage.
anything, but also medical bills.
Right.
And
Particularly, let's talk about hospital bills, right?
Right.
So those can be very, very expensive.
yeah, and that is in Connecticut one of the spouses responsibility to their spouse
Right.
is I'm not going to say limited to, but they do have a duty to support their spouse and to pay their medical expenses.
Absolutely. There's a statute. There's a specific statute. I'm not going to give it on the air, but there is a statute that addresses that spouses are responsible for each other's bills, which include medical bills and hospital bills. So you have to understand that. Now, let's kind of push that forward and talk about whether a spouse is responsible for paying nursing home. But go ahead. I saw you give me a look, so go ahead.
Well, because when you said spouses are responsible for paying their spouse's bills, I disagree. I'm not saying in its entirety.
Thank you.
However, so here's a scenario: you have spouses,
Yes.
and one of them takes out a credit card in their own name, and they go and they take that credit card and they go to the Bellagio and they gamble. They take out cash and they run up a $20,000 credit card bill by themselves. Mm-hmm. Does their spouse who didn't go on that trip?
Did they win anything?
Benefit?
Did they win?
No, they lost everything.
Because if it benefited,
the odds are against you, right?
You're going to lose more than you win at these casinos.
But that's the scenario. So
but if the spouse who didn't go benefited,
well, right, but that's the scenario I used though. This one spouse went and they spent the money themselves. They're the only ones that got the benefit of the vacation. They're the ones that blew had the fun at the craps table, crapping out the whole time and all that. Yep. So the question is, does their spouse that stayed at home, do they have responsibility for that credit card bill?
no.
Right. So there is an exception, right?
Well, credit card bills, but I was talking about hospital.
There's always an exception to the rule, isn't there?
I know, but we need to be precise,
This is what happens, folks. Again, I'll say it again. When you get 2 attorneys, it's almost like a boxing match. This is why
That's right.
you can go against each. I know you're on the same team.
The
You
brain
can-
trust.
That's what they teach you probably in law school, right? There's always an exception to the rule. There's always another way to look at something.
Right. And I just think it's important that, and I know Marianne does too, so I'm not, we think it's important though that, well, first of all, that people do understand there are exceptions and that we've given you some of them today, but there really is no substitute for every situation is different. Every fact pattern is different. Mm-hmm. And so until you actually speak with an attorney who has the type of practice that we do, that you're not going to be able to get a full appreciation for the exceptions. What are the nuances? What are the, it's so we're talking in generalities, and I don't know if we should make this disclaimer at the beginning of every one of these, is that to say that nothing that we say today is legal. It should be considered as legal advice.
That's right.
Or that we're creating any type of attorney-client relationship with any of the listeners out there, because that is not the case here. This is for educational purposes only.
Sure.
Thank you, Ned.
I think
he's right.
He's covered his legal disclaimer.
He's done a good job.
You have.
So,
and we've got less than 2 minutes left.
So let's just kind of close out the Medicaid piece in those 2 minutes and just have our listeners understand that it is complicated and you can't just start giving your money away because it's going to come back to bite you. And whether you come to attorneys like us, whether you go to the nursing home and speak to the social worker or the staff there, you need to be able to talk to someone before you get yourself into a boatload of financial trouble.
Nothing like making a personal appointment, because everything, it's not one size fits all. It's all customized.
And I think it's also important to, especially if you are a spouse who is placing your spouse in a nursing home, that be careful about the documents that you're being asked to sign.
Oh my God, thank you.
All the more reason to have you look at them. That's what you're paid to do. That's your area of expertise. And to do that, my friends, all you need to do is write this phone number down, as well as this website. I would start with the website, charteroaklaw.com. Once again, www.charteroaklaw.com. But this phone number is what's going to enable you to obtain that meeting. Call them at 860-570-1229. Once again, 860-570-1229. They've got offices in Bloomfield, Danbury, and Norfolk. By the way, if you want to email the show, legalnotes@charteroaklaw.com. Maybe it'll be your email.
Yeah, thank you.
We read next week. For Mary Ann, Sharon, and Ned Barron at Charter Oak Law, I'm Gary Byron. Until next Saturday, thanks for listening. Have a good one, everybody. So long.